The Supreme Court strikes down student loan relief. Here's what that means for you. You are interested in the Supreme Court strikes down student loan relief. Here's what that means for you, right? So let's go together. Storage.skywusha.com. Look forward to seeing this article right here. The Supreme Court voted to strike down President Joe Biden's student loan forgiveness plan on Friday, putting an end to a plan that could have wiped over $400 billion in student loan debt for some 42 million Americans. In a 6-3 vote, the opinion of the conservative justices prevailed, declaring Biden's plan to forgive up to $20,000 in debt for some borrowers unconstitutional. The court's liberal justices, Sonia Sotomayor, Elena Kagan and Ketanji Brown Jackson, dissented. But that was not enough to overturn the decision. The 9-member court first heard oral arguments for 2 student loan-related cases in late February as they assessed whether provisions in the Higher Education Relief Opportunities for Students HEROES Act gave Department of Education Secretary Miguel Cardona the statutory authority to forgive loan debt. The Secretary asserts that the HEROES Act grants him the authority to cancel $430 billion of student loan principal. It does not, Chief Justice John Roberts wrote for the majority opinion. We hold today that the Act allows the Secretary to waive or modify existing statutory or regulatory provisions applicable to financial assistance programs under the Education Act, not to rewrite that statute from the ground up. More than 16 million borrowers were approved for loan relief before it was put on pause by the 2 federal court rulings, and another 26 million people had applied. Now, borrowers can expect their student loan interest to resume on September 1. Payments will start to be due in October, as the debt ceiling deal signed on June 3 prevents the Biden administration from extending the student loan debt moratorium without congressional approval. Here's what the Supreme Court's decision means for you. Why was student loan forgiveness overturned? In Biden v. Nebraska and Department of Education v. Brown, justices were assessing whether the stipulation in the HEROES Act that allows the Secretary of Education to waive or modify any statutory or regulatory provisions of financial assistance programs to ease financial hardship during a national emergency applied to the administration's relief program. COVID-19 is the most devastating pandemic in our nation's history, and it has caused enormous disruption and economic distress, argued Solicitor General Elizabeth Prelogar during February's oral arguments. 2 secretaries across 2 administrations invoked the HEROES Act to suspend interest and payment obligations for all Americans with federally held loans. But if that forbearance ends without further relief, it's undisputed that defaults and delinquencies will surge above pre-pandemic levels. The court was also assessing whether plaintiffs had legal standing to sue. In Biden v. Nebraska, which was filed by 6 states, the 8th Circuit Court of Appeals previously ruled that Missouri had standing to sue based on the financial harm Missouri Higher Education Loan Authority, MHELA, would endure. The court, however, ruled that the Department of Education did not have the jurisdiction to forgive student loan debt under the HEROES Act, saying that it was an unlawful act of presidential power lacking explicit congressional approval. The one-time student loan debt relief plan would have forgiven up to $10,000 for most borrowers, and up to $20,000 for some Pell Grant recipients, whom the Education Department argued were affected by the COVID-19 pandemic.